Content warning. The following video contains material that may be harmful or traumatizing to some audiences. Viewer discretion is advised.
Just when you thought you could turn your back and walk away, the dark cloud of human indignity follows you. You have no choice but to turn and look it in the eye. It's the sex offender hit list.
Broken clock on the back wall, counting down till the last bell rings. You lock the door with the plastic smile, say this is just our little secret thing. Ink stains on my test paper, your hand leaning where it shouldn't be. You twist the rules like a gold ring, say it's love, say it's meant to be. Leave the kids alone.
Welcome back, everyone. Today we're going to go inside a Bonneville County courtroom for a sentencing hearing. It hasn't been seen until now. In fact, in just a few moments, the judge will take the bench in the case of Daniel E. Mars, a man whose past has finally caught up with his digital present. This investigation was blown wide open by a cyber tip from the social media platform X. After a deep dive into his devices, investigators say they uncovered a staggering archive of over 2,000 images featuring victims as young as just 6 years old. What makes this hearing so critical isn't just the current felony charge of possession of child sexual abuse material. It's the history the state is about to lay bare. Mars is no stranger to these halls. He has a record of hands-on offenses dating back to his youth and a history of failed rehabilitation programs. Today, the court has to decide, is he a candidate for treatment and a rider program, as his defense claims, or is he a repeat offender who has run out of chances? We have the full unedited footage of this proceeding, and you're about to hear the prosecution's evidence, the defense's plea for a second chance, and Mars's own statement before the judge makes the final decision. So let's stay tuned as the judge is entering the courtroom right now. Let's go inside.
Okay, we will go on the record this morning in Bonneville County case CR 10-25-5685, State of Idaho versus Daniel E. Morris. Present today on behalf of Mr. Morris, we have Matthew Blanksma, who is subbing in for John Thomas, and we have Mr. Morris present in the courtroom as well. On behalf of the state, we have Denise Mon, and we are here for a sentencing today. Ms. Mon, is the state ready to proceed with the sentencing this morning?
Yes, Your Honor. Thank you.
Mr. Blanksma, is the defense ready to proceed with the sentencing?
We are, Your Honor.
And Mr. Morris, the court recognizes that John Thomas has been representing you in this matter up to this point, and that Mr. Blanksma is filling in for him today. I wanted to make sure that, given the history of the case and everything, that you are comfortable with Mr. Blanksma representing you today. And if not, we could have Mr. Thomas handle this matter down the road.
I'm okay with it, Your Honor.
All right. Okay, we'll proceed then. All right. Mr. Morris, at the time of your arraignment, which was on August 11th of 2025, you were informed that an information had been filed against you by the state of Idaho, charging you with 2 counts of sexual exploitation of a child, possession of or access to sexually exploitive material, which is a felony. Both of those charges carried maximum penalties of 10 years and a $10,000 fine. At that time, you were advised of the potential penalties, your constitutional rights, plea options, and the legal consequences of exercising those options. At that time, you pled not guilty to the charges, and the court set the matter for trial. However, on February 18th of 2026, you again appeared in court with legal counsel and, pursuant to a plea agreement, withdrew your previous plea of not guilty and entered a plea of guilty to count 1 of the information. In exchange for that, the state agreed it would dismiss count 2 and not file any other charges regarding any other sexually exploitive material found in the case. Additionally, in exchange for that, the state agreed to recommend a specific sentence of 4 years fixed and 6 years indeterminate for a total unified sentence of 10 years, and that you would forfeit to the state all seized devices. You, in exchange, also agreed that you would pay full restitution and register as a sex offender. That plea agreement was a non-binding plea agreement. After you pled guilty, the court ordered a pre-sentence investigation report. The court did not order a psychosexual evaluation because one had already been done, and so that's what has been submitted to the court in this matter. The court has carefully reviewed all the information in front of it that was submitted with the PSI, which includes information about your background, as well as I believe there was a letter submitted by a family member, and the psychosexual evaluation. Have you had a chance to review that information with your attorney?
Yes, Your Honor.
Okay. Are there any parts of the PSI that need to be clarified or corrected by the defendant? Mr.
No, Your
Blanksma?
Honor.
Okay. Mr. Morris, do you agree?
Yes, Your Honor.
Okay. Is there any objection to the court relying upon the contents of the reports in fashioning its sentence?
No, Your Honor.
Does the defendant still wish to stand by his guilty plea?
Yes, Your Honor.
Okay. Are there any witnesses for the defendant today?
No, Your Honor.
Are there any witnesses for the state?
No, Judge.
Okay. All right. Will there be any impact statement from the victims in this case?
No, Judge.
All right, Mr. Blanksma, before I impose a sentence, I'd like to hear the defense's recommendations on behalf of Mr. Morris.
Your Honor, Mr. Morris asks this court to impose a 2-year fixed term plus 3 years indeterminate but to place him under retained jurisdiction for evaluation purposes. In Idaho, the purposes of justice are for public safety foremost, followed by the possibility of rehabilitation, the defendant when possible, also for individual and general deterrence, and lastly for punishment. But a period of incarceration is only reasonable if it's a minimum necessary to meet the purposes of justice, according to State v. Hill. In this case, Your Honor, Mr. Morris is taking full accountability and responsibility for his actions. He was in possession of child porn when he was in Tennessee. When this all started and came to Idaho, he continued to view that child porn. He stated in his version that he knew what he did was wrong. He takes full accountability for that. He understands his addiction issues are issues that he needs treatment for. He has a base level understanding, but he's also at that point of wisdom in knowing that there's a lot deeper issues that he doesn't understand yet. But he's amenable to looking, to getting counseling, to getting the insight, to finding those and addressing those. To know what you don't know, or rather to know that you don't know, is the beginning of any kind of wisdom in this life. He's at that place with this problem. When asked how he felt about the crime, he appropriately said it was shameful for him. That was something that broke his moral beliefs, his principles and values, a complete cognitive dissonance. He acknowledges that this crime contributes to making explicit material. That shows his insight into the addiction, shows he's teachable, and can make his way back into the good graces of the community. His LSI is 24, it's in the low to moderate range. When he was asked about his mental health, he indicated he was now on Lamictal, which is keeping his emotions level, even keel. It helps him reason through things much better. He's also very employable. He has a commercial driver's license and can make long and short haul trucking if he were not incarcerated. His criminal history is minimal. As an adult, he only has this conviction. While he's a juvenile, he does have a juvenile record, but we don't think it's fully appropriate for the PSI writer to be bringing a case up that happened 16 years ago when he was only 15 years old himself. The sexual psycho eval does put him in a high moderate risk range, but the evaluator states and acknowledges that he has an age-appropriate intimate relationship since he's been an adult. And Mr. Morris stated to Mr. Thomas, his addiction and pornography can be treated. We believe that in treatment in the community after some intensive treatment in the writer program makes sense. Given that his mental health is now stable, the environment he's amenable to treatment. He's completed numerous classes while in custody through Adobo, including sexual addiction, anger management, pornography, and a number of other items. We think the retained jurisdiction is a good program to give him a structured treatment in a controlled environment. Providing additional safety to the community while he undergoes that. It's a program that closely monitors and evaluates it. And we think that that monitoring and evaluation could be very useful to the court for a writer review to determine whether placing him in the community is appropriate. We think that's a reasonable intermediary between incarceration and immediately placing the program in the community. For that reason, we ask the court to put him on a retained jurisdiction for that purpose to evaluate his ability for treatment, as well as to meet any kind of punishment. But if he does want treatment, then maybe to consider that punishment as sufficient for the minimum necessary to serve the purposes of justice in this case. Thank you.
Thank you, Mr. Blanksma. Ms. Mon, let me hear from you regarding the state of Idaho's recommendation.
Thank you, Judge. Your Honor, consistent with the pre-sentence investigator, the state is recommending an imposed sentence. Specifically and pursuant to the plea agreement in this case, the state is asking this court to sentence the defendant to an aggregate term of 10 years with the first 4 years fixed, again imposing that sentence. This case was initiated after a cyber tip was reported by X based upon an account holder uploading a video containing CSAM in a direct message with another user. Law enforcement investigation revealed that the defendant was the owner of that account. Detectives were able to obtain a copy of that message exchange and discovered that the video contained 2 prepubescent girls whose breasts and buttocks were exposed, engaged in sexual touching. The folder also contained 2 photos of young teenagers with their breasts and or genitalia exposed, engaged in sexual touching and or oral sex, one of them with an adult male. Law enforcement also located 8 images of child erotica on the X account in which girls between 6 and 14 were in different stages of undress with their genitals and/or breasts exposed. Law enforcement officials seized various devices belonging to the defendant during the execution of the residential search warrant of this case. On those devices, law enforcement located a search history for CCM images, as well as 2 CCM images picturing girls between 9 and 15 years of age with their genitals and/or breasts exposed. Review of the defendant's devices revealed approximately 2,000 images of CSAM, and that's referenced on the psychosexual evaluation, page 9. During interviews with law enforcement, the defendant acknowledges that he has, quote, a pornography problem. That is a vast misrepresentation of what brings the defendant before this court today. Pornography in the classic sense refers to consenting adults who are engaging in sexual acts who are being photographed or recorded with those adults' permission. That is not what this is, and that is not the conduct that brings this defendant before your honor. This is the photographing and/or recording of the sexual abuse of children, which the defendant then used to satisfy his own sexual desires. According to pre-sentence reports, the defendant is, quote, minimizing the real issues, his sexual attraction to children, and that makes him a risk to this community. The defendant further reports that he used pornography to self-medicate his depression, loneliness, anxiety, and misery. Much like everyone in this courtroom, the defendant will continue to face challenges throughout his life, and his suggestion that he used the violent abuse of children to self-medicate is simply unacceptable and cannot be tolerated. When describing why and how he began seeking out CSAM, the defendant states, quote, I started looking for more perverse and taboo things as the other porn didn't satisfy my dopamine needs. I ended up finding child porn on Twitter after following someone's on there, which I was knew taboo and illegal. It satisfied my dopamine needs, not the pictures themselves, but the excitement and severe taboo of it. Anyone who believes that the violent sexual abuse of children is excitement, in particular by someone who has received intensive sex offender treatment as a teenager, is a threat to society. While the defendant seems to express remorse for his actions, that remorse largely centers around his own life and how he will be affected by his actions. He acknowledges the impact that this will have on his sisters who were victims of his, but he fails to acknowledge the harm or behavior to the victims of every single file of CSAM that he has viewed. The defendant also minimizes his conduct, arguing he did not have thousands of images because he did not download the content. He would simply just view it. Again, this is a severe depreciation of the seriousness of the offense that brings him before this court. At times, the defendant reports that the recommended sentence is unfair because others with similar crimes have received, quote, lighter sentences. And the defendant not only doesn't appreciate the seriousness of the offense that brings him before this court, he doesn't appreciate how his criminal history significantly increases his risk to the community around him. The defendant's LSIR score is moderate, which is not common for a crime of this nature in the state's experience. Typically, defendants facing a crime of this nature are evaluated at low risk. Their lack of criminal history, their ability to maintain a job, their family support, and so on often leads to that low-risk finding. In addition to the other indicators to this court that the defendant is a risk, the LSIR certainly supports that conclusion as well. The instant offense represents the defendant's first adult conviction, his second sexual offense. He served prior periods of supervision and lengthy incarcerations as a juvenile. He was committed to IDJC for just over 13 months in 2010 and another 37 months in 2012. He struggled with anger issues in family relationships, including threatening his father with an axe that's cited on the psychosexual evaluation, page 8, which contributed to violations and disciplinary actions at that time. The defendant now has convictions for both contact and non-contact sexual offenses against children. When talking about his contact with his siblings, the defendant states, quote, I was a good brother sometimes, a lot of times I was not very nice. Importantly, the defendant sexually abused his sisters from the time he was 13 to 15 years old, and this occurred on several occasions. He also physically abused his brother at times, stating, quote, I was kind of cruel to him. The defendant has 3 hands-on victims, as is cited in pre-sentence materials, and is at risk to find additional victims from the state's perspective if he is not prevented from doing so. There is no better indicator of the future than someone's past, especially in this circumstance where the defendant is unwilling to accept the harm that he has caused by his actions that bring him here today. The defendant's sister, while not a victim in the instant offense, knows him better than most, if not everyone, in this courtroom, and she details for this court her concern regarding the harm that is likely to be caused if the defendant is given the opportunity to reoffend, and that risk is significant from her perspective. Looking directly at the psychosexual evaluation, the defendant was assessed as being on the high end of the moderate risk to reoffend and recommended for above average intensity sex offender treatment after release from custody. The defendant appears to lack insight into the harm he caused the underage females and the sexually harmful images he possessed, page 3. The defendant admitted that he has great difficulty refraining from the use of pornography, page 6. He stole pornographic magazines at the age of 10 to 11, which demonstrates to this court that from a very young age, he was willing to take great efforts and to engage in great measures to satisfy his sexual desires. He reported that he would view pornography on average every other day and that he would seek illegal images every third day. He indicated that when he viewed illegal pornography images, he preferred 13 to 14-year-old well-developed females. The defendant does not believe he has a problem with child pornography, as he claims he is not attracted to children who are under age 12. Although, as this court is aware, at least one of his sisters was age 5 at the time the defendant made her a victim. And certainly, a child does not have to be under the age of 12 to be considered a child in the United States and in the state of Idaho. The defendant's actions cause real harm that he doesn't appreciate in this case. He has 3 hands-on victims. He has now created thousands of additional victims who he won't acknowledge are victims. He has received sex offender treatment, and he has served lengthy periods of incarceration that seem to have served little to no deterrent for his sexually deviant behaviors. Although there were no specific victim impact statements of the children who were pictured in the CSAM files in this case, as this court is aware, victims of this type of abuse typically exhibit fear, post-traumatic stress disorder, trauma, and an increased suicide risk. The sentence recommended by the state appropriately balances the rules and statutes which govern this court's sentence to include the potential at rehabilitation, which is very low in this case, if any, the protection of society, deterrence, both individual and general, as well as punishment, which is appropriate in this case. Thank you, Judge.
All right. Thank you, Ms. Mon. Mr. Morris, you also have the opportunity to address the court this morning. Is that something you'd like to do?
Yes, Your Honor.
Okay, go ahead.
Your Honor, I do know what I did was wrong. I know I did allow my addiction to pornography to get the best of me. I do recognize how it harmed those victims. I said contributing to the making, distribution of them. I believe treatment would definitely be beneficial. And I understand that I do be punished. I just would like the opportunity to get the help I need, that I can be a better member of society and not harm anyone anymore.
All right. Thank you, Mr. Morris. Are you, Mr. Morris, fully satisfied with the representation you've received by your legal counsel in this matter?
Yes, Your Honor.
Mr. Blanksman, is there any legal reason why I should not sentence Mr. Morris today?
None known to me.
All right. Well, Mr. Morris, based upon your plea of guilty, it is the judgment of the court that you are guilty of sexual exploitation of a child, possession of or access to sexually exploitive material, which is a felony. I've carefully reviewed the record. I've reviewed the PSI, the psychosexual evaluation, and considered the comments today from counsel as well as your own comments. I would note that, as has been referenced this morning, you do have a prior sexual offense on your record, the circumstances surrounding which are significant and extremely disturbing, and the court is very concerned about that history and in terms of how that impacts the court decision making on this particular offense. The court would note that the PSI recommendation is incarceration as well, and that the psychosexual evaluation does note that you are someone who is at a high moderate risk to reoffend, and that you need high intensity sex offender treatment. So in light of that, and the things that the court has to consider under State v. 2 Hill, which include protection of society, deterrence of the individual and the public generally, the possibility of rehabilitation and punishment or retribution for wrongdoing, the court did want to, discuss some important things that have gone into my decision making in addition to what I just mentioned. So, as I noted, you were convicted of a prior sex crime, and as part of that, you went through sex offender treatment previously, but here we are today. And so I think there's been a demonstration in the past or a demonstration based upon that even though you were given tools to be able to combat the issues that you've got, you were not successful in implementing those tools. Additionally, the court would note that in the PSI it mentions that you'd been accessing child sexual abuse material before, but that you'd stopped for a little while because you knew it was wrong, but then you started accessing it again. And you could have sought out treatment at that time, but you did not do so. So again, it's something very concerning to the court. Additionally concerning is that the way this matter was flagged and ultimately reported to law enforcement was due to uploading an image by you in a direct message to another user. And so not only do we have an issue with you accessing child sex abuse material, but sharing it with another person. As has been mentioned, your LSIR score is 24, which is a moderate score, which I think, again, is on the higher side for a crime like this. Again, high moderate risk to reoffend, recommended for high intensity treatment. And so to me, that indicates that you are a risk to society right now. And I think that you recognize that you will likely have some time away from society as well. You recognize that you need to be punished for what's occurred. The court does recognize that you have somewhat acknowledged the impact of your crime, that the community feels unsafe, and that your actions contributed to the making of new materials. However, I do want to emphasize that there are real victims here. These girls, the children, and then materials you access, they're real people. They have real lives and they have real futures. And by accessing those materials, you're abusing those girls every time you access them and share them. That abuse is something that lasts a lifetime. And so I hope you reflect on that and realize that these girls are someone's daughter, they're someone's friend, they're someone's sister. So I hope in the time that you have to think about this, that you really understand the impact, that there are real victims here, even though they may not be in the courtroom today to stand up for themselves or make a statement. The court is glad to hear that you expressed that you were relieved when you got caught because you can get help, and I do hope that you take the time you have through this to meet the goals that you mentioned, which is to better yourself, to complete treatment, and to move forward living a crime-free life. I do note that you said this is an opportunity for you to get the problems that you have under control, and I hope you do. So one of the other things that the court has to consider in determining whether to place you in the community for treatment or send you to prison are the factors that are listed in 19-2521 in the Idaho Code. So looking at those factors, the factors that are accorded weight in favor of avoiding a sentence of imprisonment are the defendant's criminal conduct neither caused nor threatened harm, and that weighs against you here. The defendant did not contemplate that his criminal conduct would cause or threaten harm. I think that weighs against you as well because you acknowledged at one point it was wrong and you stopped, but you began doing it again. The defendant's criminogenic needs indicate that the defendant will benefit from supervision and treatment in the community. I think that also weighs against you. That there were substantial grounds tending to excuse or justify the defendant's criminal conduct, though failing to establish a defense. That weighs against you. That the victim of the defendant's conduct induced or facilitated the commission of the crime. That weighs against you. That the defendant has compensated or will compensate the victim of his criminal conduct for the damage or injury that was sustained, provided, however, nothing in this section shall prevent the appropriate use of imprisonment and restitution in combination. We don't have the victims here in the court, so I think that is neutral. The defendant has no history of prior delinquency or criminal activity or has led a law-abiding life for a substantial period of time before the commission of the present crime. As we've discussed, you do have a prior conviction for a sex crime, so that weighs against you. The defendant's criminal conduct was the result of circumstances unlikely to recur. I think that weighs against you. The character or attitude of the defendant indicates that the commission of another crime is unlikely. I think that weighs against you. And then lastly, that the defendant demonstrates amenability to treatment. I do think you've expressed that you do want treatment, and the court notes that. However, the court also notes that prior treatment has been unsuccessful. Then, in considering the factors that are accorded weight in favor of a sentence of imprisonment, the first factor is there an undue risk that during the period of a suspended sentence or probation that the defendant will commit another crime harmful to another person? And I think that that weighs toward imprisonment. A lesser sentence will appreciate the seriousness of the defendant's crime. This is a serious crime requiring a serious sentence, so I think that weighs toward imprisonment. Additionally, imprisonment will provide appropriate punishment and deterrent to the defendant. I think that weighs toward imprisonment. The imprisonment will provide an appropriate deterrent for other persons in the community. I think that weighs toward imprisonment. And finally, that the defendant is a multiple offender or professional criminal, and the court would note that there is that prior offense, so that weighs toward imprisonment. So, considering all of those factors and in the court's discretion, the court's sentence will be as follows. The court will sentence you to a period of incarceration. The total unified sentence will be a sentence of 10 years with a fixed minimum of 4 years and an indeterminate term of 6 years. The court will recommend that you be placed in sex offender treatment during that time frame for above average intensity treatment. The court will also impose a fine of $1,000, court costs, any restitution, reimbursement to the state public defender's office, and that you register as a sex offender pursuant to Idaho Code 18-8307. Do you understand the sentence, Mr. Mora?
Yes, Your Honor.
Okay. All right. You are advised that you have a right to appeal to the Idaho Supreme Court from this judgment of conviction, and that you have a right to be represented by an attorney if you appeal. You're also advised that if you cannot afford an attorney, then an attorney will be appointed for you at public expense. However, you have only 42 days from today to file an appeal. Additionally, you have the right to seek relief from this judgment under Idaho Criminal Rule 35. This rule grants you 120 days to seek a correction or reduction of this sentence if you feel it was illegal or too harsh. You also have the right to seek relief under the Idaho Uniform Post-Conviction Relief Act. Such an action must be filed within 1 year from the day your right to appeal expires. Do you understand your appellate rights, Mr. Morris?
Yes, Your Honor.
Okay. All right, and if you've not already done so, you'll need to submit a DNA sample and a right thumbprint impression pursuant to Idaho Code 19-5506. If the attorneys can please turn in any copies of the PSI, if you have hard copies, give that to the clerk. And I believe there's been no bail, but if there has been bail in this case, that is exonerated. Mr. Marsh, you are remanded to the custody of the Bonneville County Sheriff to be delivered to the proper authorities at the Idaho Department of Corrections for execution of this sentence. Mr. Blanksma, anything further this morning?
No, Your Honor.
Okay, anything further, Ms. Mon?
No, Judge, thank you.
All right, okay, thank you, everyone. Your excuse, Mr. Morris.
Well, the judge has made her decision, and the gavel has officially come down on Daniel Mars. For a man with a history that includes the hands-on abuse of his own family members and the possession of a massive digital archive of over 2,000 files, featuring children as young as 6 years old, the final sentence a minimum of 4 years in prison? But it leaves many asking if our justice system is really doing its job. I mean, was justice truly served here? Throughout this hearing, we heard the prosecution describe a predator who had already cycled through intensive treatment and failed. Yet, the Rider program got still pushed for and could have sent him back on the streets even sooner. While the judge acknowledged the extremely disturbing nature of his past and the fact that every time these images are viewed, a child is re-victimized, the legal reality in this case resulted in a sentence that some may find shockingly light, given the gravity of the crimes. This case serves as a sobering reminder of the complexities and often the frustrations of our legal system when it comes to the exploitation of children. Mars will eventually be eligible for parole, maybe even as soon as that 4 years, leaving the community to wonder if the tools he's been given this time will stick. We already know they won't. They never do. I mean, the cycle is destined to repeat itself. We already know this. Well, thank you for joining us for this look into the Bonneville County justice system. No justice. Be sure to subscribe here as we continue to document these hearings and bring to light the facts of the courtroom. It's terrible. Laws need to change, people. Gotta do something. See you, Chomo.
One for Rainbow, one for Amanda.
Who you playing with, sweetie?
Amanda.
Huh? Oh, who are you?
I'm Amanda. I'm 6, and I love unicorns.
Sexual predators are seeking kids online.
We don't know Amanda.
Learn how to report abuse at end-violence.org/protect.